So without further ado, I would like to wish a warm welcome to Alex and Adara and to pass over to them to get us going. So thank you very much.
Thank you very much, Tracy. And a salutary lesson in pressing the unmute button when we want to speak. So I'm Adara Vanessing. I'm a partner in the Employment, Pensions and Immigration team at DAC Beechcroft. Alex, would you like to introduce?
Hi, I'm Alex. I'm an associate in the employment team at DAC Beechcroft in London.
So this afternoon, we are going to cover topical issues to deal with living with COVID and disability discrimination issues linked to it. We have 90 minutes, as Tracy said. Alex and I hope to get through our bit of this in about an hour so that we have plenty of time for questions and discussions. I think the benefit of this kind of discussion really is to have that exchange of views and experience as well. So please do feel free to comment either in the chat box or on mute when we invite comments and questions and to share your views. So if we go to the next slide, Alex, what are we going to cover today? We're going to look at living with COVID and the statutory framework around the protection of workers and safe workplaces. We're also going to cover a number of different scenarios relating to reluctant returners to the workplace. So I'm going to cover those two, and then Alex is going to cover the last three areas which relate to vaccination status, the latest guidelines on self-isolation and sick pay, and then recent cases relating to disability discrimination, which will have an impact in this area. So that's what we're going to cover. Please do, as I have said, raise questions in the chat box or unmute if appropriate, and feel free to raise that. So shall we move on to the next section then, which is about looking at the statutory framework around safe places to work. And you'll all be familiar that there are statutory health and safety duties upon an employer to look after the physical safety and the mental well-being of its employees. And those are set out in sections 2 and 3 of the Health and Safety at Work Act 1974, and also subsequent regulations. You'll see that we've identified in particular the management of health and safety at work regulations, which requires a suitable and sufficient risk assessment to be undertaken. And in the context of the pandemic and then subsequently increased home working, that health and safety duty, and in particular the duty to carry out a risk assessment, does extend to home working. And I'm sure you've all had to tackle how you undertake risk assessments of those working at home, but maybe we can touch upon those later on. In some ways, I think they are more difficult than risk assessments in the workplace, because however varied your risk, however varied your workplace may be, at least they are within a context where you have some degree of control as an employer. When someone is working at home, there are the usual equipment type risks and making sure that people have appropriate screen equipment and all the rest. But in addition, there are the stresses of home working and home life, the impact on mental health that needs to be undertaken, and those are elements where you may not have insight, let alone control of the risks. So it does open up the range of issues that a reasonable employer will need to consider. So these are all statutory obligations, but in addition, they are implied into employment contracts. So there will be an implied duty upon an employer under their employment contract to take all reasonable steps to protect health and safety. And the reason I mention this is because that in turn allows individuals to take action under their employment arrangements where an employer hasn't had proper regard to that duty. And in an extreme case, employees may even say, well, there's a fundamental breach of contract, and resign and claim that they have been constructively and unfairly dismissed. So that's one set of rights that may be activated if there is a breach of these health and safety duties. We're going to go on to look at some additional rights now. So Alex, if we can move on to the next slide. So this relates to the general duty to provide a safe place of work. We can come on to talk about the government guidance, but there's the, as I mentioned, the essential requirements to ensure that a health and safety risk assessment has been undertaken. And during the pandemic, there was also a requirement to take a COVID specific risk assessment. Now that's been abolished with the return to normal working and living with COVID, but it is still necessary to consider the impact of COVID within that risk assessment. And you'll all be familiar with these types of risk assessments, but they do involve identifying risks in the workplace, understanding what steps can be taken to mitigate, which include considering equipment, alternative steps, avoiding the issue. There is a requirement to engage in consultation on those with health and safety reps, and then to publish the risk assessment and associated documentation as part of complying with your duties. The one thing to flag up in this, which I think has particularly come to light during the pandemic and subsequently, is the impact for high-risk employees. Employers always knew that there was a requirement to carry out personal risk assessments, but I think that category of high-risk employees really has expanded as a result of COVID and the high-risk groups that were identified as a result of that. And to some degree, those categories will continue, even though we've now moved into a world where we are living with the risk of COVID. Shall we move on to the next slide, Alex? So something that that really has become far more prominent since the pandemic has been the health and safety rights, which are provided under the Employment Rights Act. So these were really very rarely used rights, and there was very little case law on it, but there have been some cases since the pandemic, which I'll come on to talk about in a moment. But just to summarise the rights, where an employee reasonably believes they are in serious and imminent danger that they could not reasonably be expected to avert, then if they make a disclosure about that and refuse to return to their place of work or any dangerous part of it, then they're protected from dismissal or detriments short of dismissal. So where an employee makes a health and safety disclosure of a serious and imminent danger and refuses to work, then to terminate their employment would be an automatically unfair dismissal. To cause them to suffer a detriment will also be unlawful, and that detriment, that protection from detriment, is available to workers in a wider sense. So, for example, many NHS trusts engage bank workers who may not be recognised as workers, but they will be protected from detriment under these provisions, as well as more traditional employees. There is a question mark over when it was reasonable for an employee to identify that there was a serious and imminent danger such that they shouldn't continue working. And as I said, we have had some recent cases which help to shed some light on this. They're both employment tribunal cases, but they're quite instructive. So it's worth just running through them very briefly. Gibson was a case that was dealt with last year and related to a chef in a restaurant. The restaurant closed down temporarily during the first lockdown. When it was reopened, Mr. Gibson was asked by his employer to come back to work. There were no steps taken to protect against COVID risks. No PPE was provided, and Mr. Gibson raised a health and safety concern. In particular, he was concerned because he had close contact with his father, who was clinically vulnerable. He complained of health and safety concerns, and he was effectively told to shut up and get on with it. His employment was subsequently terminated, and he brought an unfair dismissal claim. The tribunal found that he was automatically unfairly dismissed because he had raised complaints, and the tribunal particularly found that it was reasonable for him to have identified, because of his relationship with his father, that he reasonably believed he was being asked to work in circumstances of serious and imminent danger, and that was probably the reason he was selected for redundancy. So the thing to highlight there is that the protections around serious and imminent danger extend beyond the immediate employee to concerns about their family and those they live with. The case of Rogers and Leeds laser cutting it came out earlier this year, and that's a case at another extreme. So Mr. Rogers worked in a large warehouse where typically there were only 5 workers at a time employed. The employer had taken measures to limit risk of exposure to COVID. And when he was asked to come in to work following lockdown, he refused to come back to work. He said that he had vulnerable children, 2 of whom had sickle cell anemia, and he refused to come down until lockdown had eased and the risk of COVID had passed. And he was subsequently dismissed and brought his unfair dismissal claim. And the tribunal found that his belief that he was at serious and imminent danger in the workplace was unreasonable. And they found instead that he had a general concern about the COVID-19 pandemic. It didn't relate to his specific workplace. And the tribunal found that because they found that he had not been self-isolating as had been advised. He'd driven a friend to a hospital. He'd worked in a pub when he was able to, and in close contact with other people. So that was at complete odds with his concern about working in a fairly airy warehouse where steps to protect him had been undertaken. So in that case, the general danger and fear of COVID and the pandemic wasn't sufficient to translate into an imminent risk in the workplace, which allowed Mr. Rogers to basically stay away. if we move on to the next slide, so we are going to talk about disability discrimination, or Alex will, in more detail later. But the point to, I suppose, to highlight here, and one you'll be well familiar with, is that when you're dealing with COVID-related issues, then it's likely that disability discrimination issues will kick in. So that can happen in a number of different ways, but it's worth highlighting that while COVID itself, or suffering from a COVID infection, is probably not going to be a disability, the longer term impact of that, and long COVID may do, and Alex will come on to talk about that. But when an individual is disabled, as you will all know, there is an obligation for an employer to consider reasonable adjustments. And that's something which we'll consider in our case studies shortly. In addition, an individual has the right not to be discriminated by reason of associative disability discrimination. So that's where they are associated with a disabled person. And the protection, even when they're not disabled, kicks in for direct, indirect, and harassment. So direct disability discrimination, indirect, and harassment. So if an employer basically treats someone less favourably because they are associated with someone with a disability, then that may potentially amount to disability discrimination of the individual concerned. And again, we can explore that in the case study. The final area to be aware of and to highlight when dealing with managing employees within the workplace in a health and safety context is the whistleblowing protection. So similar to the health and safety protection, where someone refuses to work because there's a reasonable and imminent risk to their health and safety, someone raising a health and safety concern is likely to have made a protected disclosure or blown the whistle for the purposes of the whistleblowing legislation. And so if individuals say, for example, I think my workplace is unsafe, I don't think that the steps that you have taken to manage COVID risk is reasonable or sufficient, then that may be both a protected disclosure and a health and safety disclosure for the purposes of the protection that we have discussed already. So two sets of protection actually kick in. Whistleblowing protection is extremely wide. It covers not just employees but workers, much in the way that the health and safety disclosures that we've discussed do for detriment as well. So that does mean that classes beyond your traditional employees will be covered. So bank workers may be covered, other types of atypical workers provided to your organisation may be covered, and it is worth thinking about that when you receive such disclosures. And certainly most organisations' freedom to speak up policies that I've seen recognise this and allow for disclosures from a wider group. The whistleblowing protection covers both dismissal and detriment. So a dismissal for a protected disclosure will be automatically unfair. Employees or workers don't have to have 2 years qualifying service, and the amount of compensation is uncapped. It's just subject to provable loss. So it can be quite significant. And certainly we have seen cases where employees have said that they're whistleblowing, they are protected under the whistleblowing legislation because they've raised concerns about PPE, about social distancing, around other health and safety measures, and consider they've suffered a detriment as a result. That's certainly an area of growth we've seen in internal grievances and tribunal claims. The protection covers detriment as well as dismissal. So that may amount to any other detrimental action short of dismissal. I'm going to pause there for a moment and just check whether there are any questions from our audience before we move on. So I will move on. I can't see anything in the chat box either. So let's move on to our short case studies, and hopefully we can have some answers from our participants today. So if we move on to the next slide, Alex, thank you. We're going to consider a number of scenarios where you may face reluctant returners. And to help you, we've sketched out the pathway for dealing with any of these scenarios, actually. And fundamentally, that involves looking at why the employee won't or can't return to the office, considering the relevant legal risks, and then taking reasonable steps. So that's your analytical toolkit, for dealing with these issues. And if we move on to the scenarios that we are going to cover. So one is related to someone with an underlying health condition. The next one is someone concerned about someone they live with. The third is a maternity returner. And finally, someone who has moved location. So let's go on to the next slide, Alex, which is the first scenario. So where you have an employee who is reluctant to return to work because they have an underlying health condition, how would you address them? How would you deal with that situation? Does anyone have any views on this situation, or how have you dealt with it when you faced it?
I was going to say, don't be shy, guys. So there's something gone in the chat there. Thank you.
That's right. So Lorna said refer to OH.
Yeah.
Lorna, is that something that you have done, or is that just a suggestion based on good practice?
Well, I have to say that in the main, if we have anybody that has an underlying health condition and there are concerns about their ability to do their job or how they can work in the workplace, we would refer to occupational health. So most certainly, if there was long COVID or COVID generally, and there was an underlying health condition, we would certainly want to get a medical opinion.
Yeah, we do too.
Sorry, who was that second person that said we do too?
Pat Hanaway.
Hi, Pat.
Hi.
So it's two suggestions around taking medical advice, and I think that's critical. Thank you to both Lorna and Pat for their input there. Absolutely, take medical advice to understand whether the concern about the health condition is a valid one and supported by medical evidence, because it may or may not be that someone has a medical condition. It may or may not be that the steps that they think are appropriate to take are supported by medical advice. Once you have taken the medical advice, what other steps would you take?
From our perspective, once we get that medical advice, we would meet with the individual and have a discussion with them, and try and understand what their views were. So ultimately, we want to work together. We want to move ahead together, a joint approach.
That's really good answer, Lorna. So it's really important that medical advice is discussed with the individual concerned to obtain their input, because even if the medical advice disagrees with what the individual says, it's reasonable for you to engage with them to consider their views, and you may decide, having heard from them, that you will take a certain line of action or not, but it does involve actually engaging with the individual. I think that we've had a couple of other points that were made about this. So both Natalie and Rebecca have referred to completing an appropriate risk assessment. And I mentioned at the start of our discussion, I think, that while the one of the things that has come to the fore really is specific risk assessments for those who are particularly vulnerable. So absolutely it would be appropriate to use the OH or medical advice to inform that risk assessment. And can I ask, what would you do if the risk assessment and the medical advice both came to the point where the individual's concerns were not validated, and you felt that it was safe and reasonable to require them to come into work?
I suppose in that regard, it'd be looking at what their requests are, and then in accordance with the advice that have been received, whether we can look at any reasonable adjustments that potentially meet in the middle. So probably similar to what somebody was saying before about kind of having that open discussion with them and looking what we can do to get them back. And I know somebody's put in the chat about potentially temporary redeployments, or even in conjunction with them, and always working with them of whether it would be permanent redeployments as well. So kind of working with them on that.
Yeah. Sorry, was there someone else there that wanted to make a point?
It's weird, isn't it?
No, I'm sorry, I couldn't quite catch that. If you would like to speak, do let us know, but I'll carry on this point for now. So there are two scenarios here, aren't there? If you think about it broadly, one is that that the medical evidence and the risk assessment doesn't support the individual's concerns, in which case there's a sensitive discussion to be had about supporting performance and trying to regularise working arrangements. If, on the other hand, the medical advice and and the risk assessment. Can I check who that is? I think that you may be unmuted.
Did I miss something? It's a question. I think he's talking to me, but I don't know now.
Okay, I will carry on. If it is the case that medical advice and the risk assessment supports some kind of adjustments, then you're absolutely right. You do need to consider them. The issue then becomes, what is a reasonable adjustment? And so we have had, for example, a case where someone refused to wear a mask at work, and the reasonable adjustment that they wanted was to be rostered to do hours when there would be very few people around, so that they could basically engage in their activities without anyone near them. And my client in that case took the view that that was not a reasonable adjustment, because their duties involved fundamentally engaging with their team and with members of the public, and they couldn't do that in strange hours that the individual wanted. So that's a case of something that would be an unreasonable adjustment. But it is worth thinking about accommodations, and in particular the one that most people now ask for, we're seeing, which is working from home. So even with some frontline roles, we saw how those could be carried out during the pandemic remotely. So there are possibilities now for adjustments that I think didn't exist before the start of the pandemic. And it's important to recognise that, because the tribunals will recognise that we work in a different world where different ways of working are achievable and are realistic. So before you say no, it's important to really bottom out what is possible and what is reasonable. Shall we move on a couple of slides, because I've answered the next one, or I dealt with the next one. So we're now looking at a situation where someone is concerned about coming in to work because they live with someone who was deemed to be clinically vulnerable during the pandemic. Has anyone had to deal with this scenario in real life, and how would you deal with it?
Adara, I manage managing attendance, managing absence, and there have been occasions when there are people who are afraid because their family is clinically vulnerable or someone is clinically vulnerable. And again, sometimes there are maybe other places where they can work. Sometimes there are home working that they can take on. Sometimes when they realize what adjustments or risk assessments can be made, then they're happier that they can come to work safely. And probably again, some temporary redeployments where they can go to a place where, because of this, some facilities have been half empty because people are working from home. So when they realize that they're coming into an area that there actually aren't as many bodies in, then in most cases they're happy to come on back to work.
Yeah, it's a really good point, Pat, and I think Leslie has also echoed this, which is basically to look at this sympathetically, understand what the situation is and what adjustments you can consider, that you could apply here. So there is no duty to make reasonable adjustments for someone who is concerned about someone that they live with, but it is something to consider within the context of acting reasonably, and we have talked about the fact that health and safety disclosures do protect people when they are concerned about exposure to unreasonable risk for those that they live with. So that's a potential issue to be aware of. The other is this point about associative disability discrimination. So if you are treating someone directly, i.e. because of a disability less favourably, or because of a disability of someone they are associated with, then that may be direct disability discrimination. So if someone is working with an individual, let's say for example that they are a carer looking after an elderly parent who is vulnerable, and because of that they don't want to expose themselves to unnecessary COVID risk. If you were to say, well, that person I'm deliberately not going to invite to do certain things or exclude them from certain things because because of their parents' disability, then that could be direct associative disability discrimination. So while there isn't an obligation to make reasonable adjustments, there is still some protection that kicks in. And again, the reasonable way to deal with this is to speak to the individual, understand what their issues are, consider as a reasonable employer whether there are any steps that you can take to mitigate that, and then to explain what you can and can't do. And sometimes there will be things that you can't do. Sometimes, for example, someone may be reluctant to come in to the workplace to meetings because they have to care for someone that's clinically vulnerable, and sometimes the role may mean that that's not possible. And as long as you as an employer have worked through the situation, have understood what the issues are and explained your position, having explored it, I think that you're in a very strong position. If you dismiss it out of hand, then it could potentially lead to issues around breach of trust and confidence, because someone may say, well, that's a breach of the implied term. I raised an issue with you and you've dealt with it so unreasonably that it's a breach of my contract. We haven't seen those types of claims, but I wouldn't be surprised at some point to see one. So I think you've all answered very well on this, which is to look at the issues and explore them, consider adjustments. But the difference between this and someone who directly has a medical condition is that they have less protection. If we move on to scenario 3, Alex, which is around a maternity leave returner who would like to remain at home to have the flexibility that working with the pandemic provided. Has anyone had to deal with this scenario, and would they like to share their thoughts?
I haven't she's not reluctant to return to work because of the flexibility. It's more the reluctance of returning to work kind of as of COVID scare itself. And I'm kind of struggling with where I can go with that, especially as we know, cases have gone down, but they're going up, and yeah, so it's a bit of her role is in a hospital, so there's not a lot of working from home that can be done, and that's I feel very stuck.
Yeah, and thank you for raising that, Laura Ann. It's a really frequent scenario. So particularly with those with very young children, if you have older children who are back at school, then I think that concern generally disappears, because schools tend to be breeding grounds for germs. So unfortunately, for better or worse, children are likely to come home with a variety of things. But when someone's just had a baby or they're preschool, then we've certainly seen that concern kick in. And I suppose there's a couple of things to explore here. One is, are there any particular vulnerabilities for the child? Because generally, babies, young children, unless they've got a particular vulnerability, have tended to be less impacted by COVID than older people. The second issue is to consider whether it reflects on a deeper issue for the individual. So, are there mental well-being issues? Are there anxieties about returning to work which underlie this concern? And they may not come out obviously, or the individual may not actually express that, but these are things that are worth checking, because it may well be that there are other issues at play here which lead to this being an issue. The next point is really around, well, if the individual insists on not coming to work when they're required to, what do you do about it? So one thing to be aware of here is a potential indirect sex discrimination issue. So you'll all have dealt with this problem in different ways, I'm sure, in the past, but women are recognised by the courts as being primary care providers for children. Therefore, any employer's requirements which may disadvantage them because of those child caring requirements may be indirectly discriminatory and therefore need to be justified because women are disproportionately affected compared to men in the application of that requirement to their detriment. So translating that into this scenario, requiring an employee to come into work full time at their normal place of work may disadvantage those with primary childcaring responsibilities, which are predominantly women. So you have to be satisfied that your requirement to come in is needed. So, for example, if someone's role is to be in the front desk of reception in a hospital, that does require someone to be physically there. Whereas if they're providing some kind of administrative support that they managed to do perfectly well at home during the pandemic, then that requirement to be in the office full time may be less justifiable. And then, well, can I just check? I can see that a message came that someone lost my comments. Would someone just confirm that you can hear me? Yeah, thanks very much, Laura Ann. So the point that I was making was about indirect discrimination and considering whether your requirement disproportionately disadvantages female staff, and therefore whether you have to consider the justification for this. So this all really boils down to the point that I think some of you were making, which is that you should look at the need for the requirements that you put in place and whether they are necessary as part of the role, whether you can reduce them in some way, for example, by allowing a short-term arrangement or a graduated full-time return to work, effectively considering reasonable adjustments but in a different context. And the final point to make here is that to consider whether a formal flexible working request is appropriate, and that would permanently change someone's working arrangements, but that might allow you to consider the request in a more formal framework. I'm going to just check the chat box because I can see that Gillian has posted a comment, which is that she has a staff member who has returned to work but due to circumstances has no childcare and wants to work from home. We've agreed to let her work from home for 1 day a week before we knew that she had no childcare. Is she entitled on demand that we allow her to work from home? She did briefly before the baby arrived. The traditional right to flexible working has been related to childcare or other care arrangements. Many organisations have extended that policy, and some even have no requirement other than that someone makes a request. So I think the first answer to this question, Gillian, is to check what your local policy says and the circumstances under which you will agree to flexible working. But once you agree flexible working, often that will be a permanent variation unless you've agreed otherwise. So you may trial it, you may agree it's temporary, but if you don't, then there is a risk that you've actually agreed a permanent change, and so you do need to consider whether it's necessary to change that. I think it's always possible to change even permanent arrangements, but it does require more care because you're potentially changing someone's arrangements, which may be contractual and which may lead to other rights being engaged, and if badly handled may lead to a potential constructive dismissal risk. I'm going to touch very quickly on the last one before I hand over to Alex. My apologies, Alex, that we've overran, but we've had some good comments and interactions. So I'm grateful to everyone who has participated so far. So the final scenario is what happens if someone is reluctant to return to work because they've actually moved home. And I've had a situation where someone has actually moved country, and it only came out that they had left the country when someone was trying to meet with them, and it became apparent that they were in a different time zone. So has anyone had to deal with a situation where individuals have moved and therefore are reluctant to come into the office?
Adara, we've had a situation where a fairly junior member of staff is living quite a distance, and recently most of our people have been sort of called back, and they're being given the option of what we're calling hybrid working, where they can work from home and work in the office. But the petrol prices have impacted on them, and they're traveling quite a few miles every day there and back. And so what our suggestion was at that time was to apply for the hybrid working through the flexible working arrangements. And this means that they can work maybe 2 or 3 days at home and the rest in the office. And they do work with a lot of information and a lot of computer work. So, and they've been working at home practically nearly 2 years. So there really shouldn't be an issue.
This is a really good point, Pat. Thank you for raising that. You know, at the end of the day, people are scarce. The NHS is competing with lots of other employers for talent, and therefore the starting point should be, you know, can we accommodate this? Is it inimical to normal working arrangements? And sometimes someone does a job which requires them to be in for a minimum period of time. So you know, we've all heard the arguments around team collaboration and innovation, collegiality, and all of those things. So those types of requirements, the need to see patients face to face, you know, those kinds of things may mean that there is a minimum requirement for someone to be working at a particular physical location. But outside of those, you should consider, you know, what adjustments, if any, can be made around this. And as we've discussed, it's possible that to stick to a strict requirement may result in, you know, either people voting with their feet, or it may result in a potential constructive dismissal claim if people say, well, there's no reason for this, and I work flexibly during the pandemic and more effectively, and now you're being unreasonable as my employer. So, you know, we've seen that raised in the past, and then there are also the linked sort of discrimination type issues that we've touched upon, and whether it's indirectly discriminatory to require someone to be in a specific place of work at a particular time. But the starting point for this one is that unless you've changed someone's contract so that they have a contractual right to work from home or a different place, then you do and can require them to attend for work, but that does need to be tempered by some flexibility, given the working conditions in which we've all lived in the last couple of years. So I'm going to hand over to Alex now to discuss vaccination status.
Thanks, Dara. So I want to quickly go through vaccination status and some latest guidance on self-isolation and sick pay. But first, on vaccination status, as you're all aware, I'm sure, the government revoked its proposed regulations earlier this year, which required vaccination for COVID-19 as a condition of deployment in healthcare settings. They are still obviously advising all healthcare professionals to get vaccinated as part of their professional obligations, but the requirement that they do so has now been revoked. So the question of, you know, what you can ask about an employee's vaccination status now really becomes a question of data protection. And the short answer is yes, you can ask employees to disclose their vaccination status, but you do need to consider whether it's reasonable or necessary to do so. And that's because vaccination history and information is personal data, and because it relates to health, it's a special category of data, which means there are more requirements in terms of how you process that data and the reasons why. So, for example, you need a legitimate reason to process that data, and it needs to be a reason that's listed in the Act itself. But health and safety in the workplace is one of those reasons that you can ask people about special categories of data, including vaccination status. So you'll need to consider whether you need that information as part of your assessment, and this ties back into Yadara's first section about, your ongoing risk assessments in the workplace and making sure that you're providing a safe workplace. Do you need to know the vaccination status of your employees to do so? And is it the most, because it is special category data, is that the most reasonable data to ask for? Is there a lesser or less sensitive category of data you can ask for that would achieve the same purposes? So, for example, we suggest in line with the government's most recent guidance, you should think about whether you need to know about someone's vaccination status, or whether actually you should be relying on lateral flow test results to deal with, employees who are potentially infectious and preventing them from obviously spreading that in the workplace. And I'll touch upon that when I talk about self-isolation in a moment. But we know with the Omicron variant, having a vaccine is not an indicator that you'll be less infectious or less likely to get the disease. It prevents you perhaps from getting it more seriously, and therefore is it reasonable to require vaccination status information to prevent onwards transmission in the workplace. As I said, special category data has implications for how the data is stored, and the information obviously that is given to employees about how an employer is using that data. So in the information that you pass to your employees, there will be a section, I'm sure, with how you process special category data. So you do need to consider that if you continue to do so. One area that we have flagged, and something that we are seeing a few questions on, is employers who already have COVID-19 vaccination data for their employees. Now, this may have been gathered for a number of reasons. One, it could have been to comply with the now revoked regulations, or quite commonly, where you are also a vaccination centre, you will hold information in relation to your employees and their vaccination status. Now, if you are holding it because you are a vaccination centre and it may be needed for future treatment purposes, that is a necessary and a reasonable requirement, and therefore you're fine to continue holding that data. If you're holding it purely to try and comply with the now revoked regulations, you may need to think about whether you still need to have that data and do an assessment of that. So as I said, I've already previewed the fact I'm coming on self-isolation. And as you all know, the requirements, the legal requirement anyway, to self-isolate following a positive test ended earlier this year, and there's no longer a requirement for close contacts of a positive case to self-isolate either. While we don't have a legal requirement anymore, there are obviously government guidelines around when particularly healthcare workers should isolate. And these are particularly when you have symptoms of a respiratory infection. So, for example, a cough, a sneeze, a fever, high temperature, or a positive COVID-19 test. And the guidelines, I've set them out on the slide, but in summary, if you have symptoms and a high temperature, you should stay at home and avoid contact with others, and you should take a lateral flow test. If you get a positive lateral flow test, you should not attend work for 5 days. And if you are patient facing, you can only return to work, or you should only return to work when you've had 2 consecutive negative test results taken 24 hours apart and taken after day 5. Close contacts of a positive case, and this is where it's quite different now, the guidance. Close contacts of a positive case who haven't tested positive themselves are no longer required to self-isolate or advised to do so under the guidance. However, the guidance does suggest that they have a discussion with their line manager to discuss how they might minimize the risk of onwards transmission. So particularly if you have someone who is a close contact and they work in a ward with immunosuppressed patients, you may want to consider whether they should be redeployed to a lower risk part of the hospital, or you might want to limit their contact with others, particularly if they work in crowded or poorly ventilated spaces. And obviously, if that people can work from home, perhaps thinking that they should do so for a period of 5 days in line with the other self-isolation guidelines. And then sick pay. So I've laid out 3 questions there. These are the 3, I think, top questions that we get around sick pay and COVID-19. The first one is becoming increasingly redundant. Should somebody be paid if they need to self-isolate? There's now a very limited requirement to self-isolate, and it's almost entirely going to be because you've got COVID-19 and therefore you are off sick with COVID-19, which is my second question. As I said previously, employees who do not have any symptoms or have tested negative don't need to self-isolate. So you shouldn't need to be paying people for self-isolation anymore. What should someone be paid if they are off sick with COVID-19? Well, at the moment, staff should receive full pay, inclusive of all enhancements, in line with the COVID sickness absence regime. And if that was to be revoked, obviously, that situation would lapse to normal sick pay arrangements. So do keep an eye out. That regime is still in place at the moment, but were it to be revoked, COVID-19 would revert to normal sick pay arrangements. And then the final question is around COVID-19 and sickness absence triggers. Now, as part of the COVID sickness absence regime as it currently stands, short-term COVID-19 sickness absence should not be included for the purpose of managing sickness absence. Obviously, if that regime is revoked, then you would revert to your usual sickness absence management process for short-term absences. Long COVID, and we're going to come on to discuss a recent case about long COVID, but it may be considered a disability. So if you have a case of long COVID and you're thinking about sickness absence management, you should be treating it as you would treat any other disability related absence. So that's a very whistle-stop tour through the latest updates on those. Before I move on to disability discrimination, does anyone have any questions on vaccination status, self-isolation or sick pay? Yadara, are you able to check that? Laura Ann, hi.
Hiya. I think kind of the main question everyone has on their mind in my team is how long, well, as you said, it could be under Disability Act, but how long, is there any kind of more conversations about when this might come to an end? Because I know that some managers are kind of getting a little bit frustrated, I would say, of having to pay staff for long COVID, whilst they've been off for long-term sickness.
Yeah, I mean, I think I think there is, it will obviously come to an end at some point. That COVID, the cases are going up, but obviously we are seeing less absences generally due to COVID as a whole. But I don't think we have a specific date, or there hasn't been a specific. I'm looking at Yadara here in case he has information that I don't have.
No, well, just on the issue of long COVID, we've been asked about this many times, and I think that in the chat function, Gillian's raised this as well, because my view is that those special COVID arrangements don't apply to long COVID. They apply to effectively when someone is symptomatic with COVID. Long COVID is the long-term results of having had that infection. So in other words, it should fall within the normal sickness absence and pay arrangements, which does mean that at some point, if people have it beyond their full sick pay entitlement, they should drop down to half pay or statutory sick pay once those arrangements have been exhausted. And I know that some trusts historically have taken a more generous view of it, but I think living with COVID now does mean trying to regularise arrangements. And I can see Anna Alexander has raised the same point about someone being on full pay for up to 2 years. So I think in those situations, it's a question of making clear to the individual that you've exercised a discretion and interpretation of your sick pay arrangements, but that you will be moving on to onto the normal sick pay arrangements at a certain point in time, and what that means for them. So the key thing is that if people's pay is to drop, that they have advance notice of that and what it means. But I do think that it probably does need to be tackled in the cases that you've identified in the chat boxes.
Thanks,
And I think
Tara.
Catherine raised the same point. So after you.
So unless there's any other questions on the sick pay point, I will move on to the final section of today's session, which is developments in disability discrimination. And we're going to be covering 4 cases this afternoon that have happened in the last couple of years. And just to give you a flavour of some of the developments that have taken place in the sphere of disability discrimination. And the first case we're going to discuss is Mr. Seacombe and Reed Partnership, where the EAT, the Appeals Tribunal, upheld a decision that an employee wasn't disabled, and if he was, that the employer had no knowledge of his disability. So to give you some background to this case, Mr. Seacombe was employed as a supply chain manager, and when he started in his role, he filled in an equal opportunities monitoring form in which he responded no to the questions asking if he had any health related issues or impairments for which he might need adjustments. At the end of his probation was extended, and he complained that he was disgusted about his treatment, but again didn't suggest that any performance related issues were because of any underlying health conditions. He then suffered a traumatic event and was off work sick for a period of time and was extremely upset. He attended a meeting with his manager who offered to provide cover for him if he felt too ill to work, and he was also given some compassionate leave. But during this time, he never suggested to his managers that he was suffering from an underlying health condition. After he returned to work and he was certified as being fit to do so, he filled in a performance management document and he referred in that to his need for emotional recovery, but again didn't mention any specific mental health impairment. He was subsequently dismissed for poor performance, and at the dismissal meeting he was very upset, but again didn't assert that his performance had been affected by any mental health impairment. At the Employment Tribunal, Mr. Seacombe claimed that he was suffering from severe anxiety and depression, and that constituted a disability, and that he had therefore suffered disability discrimination. Well, the tribunal held that he wasn't disabled, and that in the alternative, that the respondent, the employer, didn't and could not reasonably have been expected to know that he was disabled. And so that point was appealed to the Appeals Tribunal, and they dismissed the appeal, and they said there was no evidence that to support his assertion that he was disabled. They had 10 years of medical notes for him, and it didn't reflect a diagnosis of severe anxiety or depression. And the court also considered whether the respondent should have known that he had a disability. And they said that although there had been previous instances of mental health impairment, those had been before he had been employed by the respondent in this case. And they didn't suggest that any impairment was going to have a long-term adverse effect, which we're going to come on and talk about in one of the other cases. And they also said that he had multiple opportunities to have raised this. He didn't mention it in the monitoring form. He'd had a number of conversations with his colleagues, which were described as frank and personal, but hadn't in any of these discussions mentioned a mental impairment that might amount to a disability. So although he had suffered from severe distress preceding the termination of his employment, they believed it was a one-off traumatic event, not an underlying mental health condition. So what does this case mean for employers? Well, it's not unusual in our experience for candidates or employees to withhold information about a mental health condition or a disability because they wish to maintain their privacy or are concerned that there may be an adverse reaction to them declaring that information. Withholding information can be relevant. Also, I've clicked onto the next slide, but withholding information can be relevant to the question of whether or not someone is disabled or not, or whether they should have known, an employer should have known about the disability, but it's not determinative. And it was in this case, it was part of the determination in this case, but employers should be ready to ask questions about an employee's health. And if they think there's a possibility of an underlying health condition, whether that might have an impact on an employee's working life. So going on to my second case, this is the case of Mr. Sullivan and Berry Street Capital. And this is a Court of Appeal decision from November last year. And this was a case where the Court of Appeal said that an employee who had suffered from paranoid delusions was not disabled because the adverse effect of on his ability to carry out normal activities was not likely to be long term. So again, going through some of the facts in this case, Mr. Sullivan was a senior sales executive at the respondent, and he had a relationship in 2013 with a Ukrainian woman. After the breakdown of that relationship, he became convinced that he was being stalked and monitored by a Russian gang connected to this Ukrainian woman. And this had a real significant impact on his life at that time. He changed the locks at his home, he installed CCTV, he went off the grid on his mobile devices and was frequently changing his email addresses. His sleep was disturbed, he sometimes slept in a hotel, he withdrew socially, and his work attendance, timekeeping and records at work were all affected. Now, it's important to say in this case, the respondent had some concerns about his performance before all of this took place. And before all of this happened, he hadn't had any previous psychiatric issues. But later on that year, he recovered, and he travelled with work, and he got back to a normal functioning at work. But in April 2017, he deteriorated again, and he subsequently went off sick later that year. And this was all triggered by about a round of pay negotiations, which were close to resolution, but they hadn't quite reached an agreement. And the day after he was signed off sick, his employment was terminated, and this was on the basis of his capability. The respondent in this case said that his poor timekeeping, his lack of communication, and he had a number of unauthorised absences and poor record keeping amounted to a dismissal. So Mr. Sullivan claimed he had been unfairly dismissed, and he suffered discrimination arising from his disability. The tribunal held, and they found that he had been unfairly dismissed, but that he was not disabled, and therefore couldn't bring his claims of disability discrimination. So we dropped the unfair dismissal claim at this point and focus on the discrimination claim. And he appealed that to the EAT, which was also turned down, and eventually to the Court of Appeal. And the question was he a disabled person or not? And the key question for the Court of Appeal was whether the effects of his paranoid delusions were long-term. So the test for that is whether it's likely to last a year or to recur. So for a condition to amount to a disability, the effect of the disability on the day-to-day activities has to be long-term as well as substantial and adverse. And it was clear Mr. Sullivan had substantial adverse effects from those paranoid delusions over two periods of about 4 to 5 months, one in 2013 and the second in 2017. But the evidence didn't show that there was a long-term effect that was likely to last 12 months. And they also said that there was a specific trigger in 2017 of these pay negotiations, which suggested that it wasn't likely necessarily to recur on a regular basis. So the Court of Appeal said that it wasn't a long-term adverse effect, and therefore he was not disabled, and he was not successful in his appeal. So again, what does this mean for you? Well, first, and this is advice we give whenever we get a discrimination claim on disability, whether or not a condition amounts to disability will always depend on the specific facts. It is a relatively low legal bar. However, there are cases like this where you have to go through all of the limbs of the test to make sure that disability is found. And a condition will not be a disability unless the substantial adverse effect are likely on the day-to-day activities are likely to last at least 12 months or to recur. And this is the case even if the condition is still ongoing. It's the impact that has to be long-term, not the condition itself. So moving on to my next case, this is DWP and Bowyer's. This is looking at the decision-making process when considering discrimination arising from a disability. And in this case, the appeals tribunal held that the employment tribunal had erred in law by focusing on a decision-making process rather than whether discrimination arising from was objectively justified. So the facts of this case are that Mrs. Bowyers was employed by the DWP. She had migraines and panic attacks, which she said had been exacerbated by bullying and harassment at work. There were some attempts to deal with her concerns about bullying and harassment. They moved her away from the colleague and into a new team. But she was subsequently signed off work with stress after a conversation with a customer. And she then raised a grievance about how her allegations of bullying had been dealt with. And she didn't return to work from that period of sick leave, apart from a trial period that wasn't successful. So after about a year's absence on sick leave, the DWP terminated her employment as they decided that she wouldn't be able to return to work for the foreseeable future. Well, she claimed that she'd been unfairly dismissed and suffered discrimination arising from a disability. And the tribunal upheld her claim of unfair dismissal. The DWP agreed that Mrs. Bowyers was disabled and that the unfavourable treatment that she had suffered arose in consequence of her disability. So the question was whether the dismissal was objectively justified. In other words, was it a proportionate means of achieving a legitimate aim? Well, the employment tribunal held that the DWP had two legitimate aims in this case. One was protecting scarce public resources, and the second was reducing the impact on other employees from her absence. However, the tribunal held that the dismissal was not justified because dismissal was not a proportionate means of achieving either of those aims. So the tribunal said that she had been subjected to discrimination arising from a disability. Well, this was appealed by DWP, and actually the AT upheld the appeal. And they said that in order to assess whether a potentially discriminatory measure, so in this case the dismissal, is or is not proportionate in the context of the legitimate aim that the DWP were pursuing, a tribunal needs to weigh the real needs of the employer against the discriminatory effect of the proposed dismissal. So in this context, there's got to be a balance between the discriminatory effect of the dismissal and the reasonable needs. And the tribunal had failed to do this because it focused on the criticism of the DWP's decision-making, which led to the dismissal. And the tribunal had not assessed the DWP's needs or discussed the evidence in relation to the two legitimate aims. And they said the fact that the dismissal was unfair doesn't necessarily mean that it's also disproportionate. So what does this mean for employers? Well, a successful defence of claims of discrimination arising from a disability will often depend on whether or not an employer can objectively justify the treatment of the employee. Employers who are contemplating action in relation to employees who are or may be disabled should consider whether there is a possible link between the action and the disability. And if there is, the employer should consider carefully whether there are other ways of achieving their aims which may have less of an impact or less of a negative impact on the employee. And finally, I did say I'll come back to long COVID, and here it is. This is a very recent case. This is from this month, in fact. And the long and the short of it is the ET has held that long COVID is capable of being a disability under the Equality Act. So the case is Burke and Turning Point, Scotland. And to give you the facts in short, Mr. Burke was employed by the respondent as a caretaker and security guard. He first got COVID in November 2020, and he hasn't returned to work after this date and was eventually dismissed in August last year. He got a mild bout of COVID at first, but after his isolation period ended, he got severe headaches and fatigue. His symptoms were quite unpredictable, and that made him quite anxious as well. And they said he lost weight, he lost his appetite, and he was diagnosed with post-viral fatigue syndrome. Now, the interesting point in this case is actually Mr. Burke went to occupational health on 2 occasions, and on both occasions, the OH assessor said that he was medically fit to return to work, and that they concluded that it was unlikely that the Equality Act would apply to Mr. Burke. But he didn't return to work despite the OH advice, and he said his symptoms continued to fluctuate. So when he was assessed, he was on having one of his better days, but then he would deteriorate after that. He was eventually dismissed in August 2021, and they said that you're still too ill to return to work, and that they couldn't assess. They couldn't see a time when he would be fit to return to his work. So it's important to note at this stage, I mean, this is just a preliminary decision on the issue of disability. So we don't know what the tribunal decided in relation to his claims of discrimination, but we do know that they've said that they've looked at the issue of disability and decided that long COVID is capable of being disability, and that Mr. Burke was found to be a disabled person in this case. Now, they said that going through the test, they recognised that long COVID is a physical impairment, and the question was whether it had a long-term adverse effect on his day-to-day activities. And they sided with the claimant on that. There was a discussion whether he was exaggerating his symptoms or whether they fluctuated, as he said. But he had relatively consistent evidence which suggests it did. Something that was quite persuasive for them on terms of the long-term aspect of it was the fact that he'd already been off for nearly 9 months by the time he was dismissed. And in the dismissal letter, the respondent had said it was unclear when he would be fit to return to work. Now, with only 3 months left to go until the 12-month cutoff period, they said, it's unlikely. If you're saying he's unlikely, you can't foresee when he'll be fit to return to work, it's unlikely that it will be in the next 3 months. So what does this decision mean for employers? Well, I think there's 2 important points to take from this. One is that employees returning to work after long COVID may well be considered to be disabled under the Equality Act, especially if their symptoms are continuing or fluctuating. Consider obviously occupational health advice, as we've discussed earlier in the session, for anyone returning after a long period of absence, and also consider any adjustments that may be necessary. The second, I think this is particularly interesting on these facts, is the OH advice in this case twice said that they didn't consider it to be a disability under the Equality Act. Now, it should be OH advice on that test is a legal test, so OH advice should be treated with caution. While it can be a good indicator of where the decision may be taken, in this case he was twice assessed and twice said he didn't have a disability, but the tribunal took a different view. So it's while OH advice on that point is great, it's not always going to be a silver bullet in terms of winning the point on whether he's disabled or not. So that is a whistle-stop tour of the latest developments. Does anybody have any questions?
Actually, Alex, I'd like to touch upon a couple of the comments that have crept up in the chatter box. So there's been a really interesting discussion about the management of long COVID, both in terms of pay and in terms of triggers for performance management and ultimately dismissal. I think it's worth saying a couple of things. One is that I don't think practice between different NHS trusts is consistent on this, and I think that partly may be because the guidance both issued at DHSC level and by NHS employers, when you start to unpick it in detail, doesn't necessarily allow for that sort of consistent interpretation. My view certainly is that the guidance relates, and the origination of the special scheme for COVID really related to infectious COVID, because the idea was that NHS staff shouldn't be disadvantaged by reduced pay or triggers and required to come into work, which might actually pose a health and safety risk. So certainly the one of the issues that I've been talking through is whether actually, when you look at the scheme, if that's its reason, why would it be applicable to long-term COVID, which is non-infectious? It may be ultimately arising out of an original COVID infection, but why is it different in principle from any other disability or malady that someone may suffer in the longer term? And in principle, there doesn't appear to be a justification for why that should be treated in a different way from other disabilities or other impairments of a long-term nature. And I think the point's made by a couple of people in the chat function that people on long-term COVID sickness have actually been paid for more than a couple of years now in some occasions. Where is the end going to be? I've heard, like others on the chat function, that the guidance is being reviewed, so I'm sure we will get some clarity on this. But I do think it is possible, even on the basis of the current guidance, to argue that the arrangements that were put in place for special COVID sickness absence was in relation to infectious COVID, and additionally that the guidance doesn't create a contractual change from the requirements of section 14, and that does mean that ultimately it's the section 14 AFC requirements in relation to pay and triggers which are relevant. Gillian's quite rightly identified that she had a colleague with cancer treatment and someone with COVID, and the person with cancer has had to come back to work while the person with COVID is still off. So the situation does lead to some inconsistencies in the treatment of long-term sickness absence, which I think that trusts are entitled to regularise and tackle. And I don't think that is inconsistent with the current published guidance, particularly when you unpick that guidance and see what it says. But that may be a controversial view. We have about 3 or 4 minutes left, and we've had actually a really good discussion. I'm grateful to everyone who's participated, and also for everything in the chatter function, which has really helped us to ensure this discussion is as interactive as we could have made it in the circumstances. Can I pause and just check if there's anyone with another question or two before we wrap up?
I think there is one in the chat function from Leslie Adara. I think so. This is a question. Leslie's question relates to surgical masks being worn with direct patient contact, and due to some of the COVID measures, whether there is any case law advice around exemptions for mask wearing for healthcare staff where they struggle to wear masks due to health reasons. I would say, before handing over to Dara on the point around the case law advice around exemptions, there has been some updated Department of Health guidance in the last couple of weeks on infection control and the wearing of masks, and that has been updated, and that is on NHS employers online to access. But Dara, do you have any thoughts on the point around perhaps discrimination on health grounds if they're being asked to wear a mask?
Yeah, and I think this really does relate to the points that we've discussed around understanding what the medical condition may be, and then understanding whether that's a disability which triggers reasonable adjustments. On the face of it, I think in the NHS you have very strong arguments where someone is in a patient-facing role, that even if they have a disability which prevents them from wearing a mask, that provided your risk assessment requires that to be done in order to protect patients, that is actually a justified policy. And certainly I've had to defend this in the context of a case where someone did bring this claim, and in the end the individual withdrew their claim, but I was fairly confident that even if it was potentially an adjustment that related to the disability, the policy was justified on the grounds of protecting the health and safety of patients. So I start from a bullish point of view, which is the requirement for PPE masks within a patient care setting. I think is you're going to have a degree of discretion, and the tribunal is going to defer to a trust when it says it's necessary to protect patients. But what's important is you explore the requirement, you understand what the individual's condition is, and you look at whether other adjustments are possible. So are there other duties that they could be required to do, or other roles, or other ways of accommodating their situation? So that was a very useful intervention. Thank you very much for that.
It wasn't.
I know that a number of people have had to log off because we're hitting our allotted 90 minutes. So I'd like to take this opportunity to thank everyone who's joined us, to thank Alex for co-presenting with me, and to thank the HPMA for hosting this event. Thank you very much, everyone.